In SHUFFLEBOTHAM and Another versus SHUFF-WENTZEL, the claimants, 2 of 3 executoresses, applied to replace all executors and trustees and to remove the defendant, the 3rd executrix. His Honour Judge Charman, sitting as a High Court judge, permitted the claimants to resign, but refused to remove the defendant, appointing a professional trustee to act alongside her and a family representative. The defendant was the overall successful party, entitled to her costs. The court was required to determine whether the claimants should pay those costs personally and whether they could recoup them from the estate. Applying Buckton and Price versus Saundry, the judge characterised the proceedings as hostile litigation, closest to a beneficiaries dispute, making the claimants jointly and severally liable personally. However, examining their conduct against the principles in Lewin on Trusts, the judge held they had acted honestly and reasonably in bringing necessary proceedings to address a genuine deadlock. Their right to indemnity from the estate was preserved, entitling them to recoup the costs paid. Quote, "In my judgment, the claimants acted honestly and reasonably in bringing the application and in including in it an application for relief which included the removal of the defendant. The fact that I ultimately decided not to remove her does not establish that seeking her removal at all was necessarily unreasonable. I do not consider that it was. In my judgment, the application was not one brought for the first claimant's own benefit or for the benefit of some beneficiaries over others. There was a genuine deadlock as a result of the breakdown in the relationship between the claimants, in particular the first claimant and members of her immediate family and the defendant. The application was necessary."
For a detailed summary of this decision, visit tmclegal.co.uk.